Thank simply introduce them to you as in relation to what they currently do. Lindsay Marshall is Executive Director of the Florence Immigrant Refugee Rights Project. If some of you are not familiar with it, it's been referenced a lot today. It's a wonderful organization. Victoria Beckman is a deputy. Is that correct? Is that what it's called?
I think we're assistant.
Assistant? Okay. Assistant Maricopa County Public Defender. And previously an assistant federal public defender also in Phoenix. Regina Jeffries is a private immigration attorney, and she's also the chairperson of the Arizona chapter of the American Immigration Lawyers Association. And then last but not least, Andy Silverman, who's a professor in the law school and director of clinical programs, I believe, at the Law College, correct? Of the University of Arizona in Tucson. So without further ado, I'm just gonna, the way we're gonna do it today is we're going to just have everybody talk a little bit about the work that they do, and then I'm gonna ask a few questions and then we'll open it up. Okay, so Lindsay, go ahead.
Sure. Just describe what we just said.
Yeah,
Okay, so good afternoon. We try not to be offended about where we place attorneys in the pecking order, that we're at the end of the day when people are leaving.
It's really the grand finale.
Exactly.
Oh, okay, so we'll interpret that way.
No, I planned it all out.
Yeah. You know we'll stay. So anyway, thank you for organizing this to Human Rights First and for having us. So I'll just briefly talk about the Florence Project's model of providing legal services to people in removal proceedings that are detained in Arizona, a couple of limitations on that model, and then probably get into some other things when we talk about, go through questions. To start with, we have what we call a pro se model that essentially served as sort of the blueprint for what is now the National Legal Orientation Program across the country. I believe it's in 20 different detention centers around the country now, which is a small scale compared to the fact that people are in 250 facilities around the country, but it is a start. Essentially what we do is we provide a large Know Your Rights presentation to every detainee in the facility before their first court hearing. We do those, we try to do them about a week before people's first appearance before an immigration judge. Explain to them why are they there, how they might be able to get out on bond if they're eligible for bond, and then we go through the different legal defenses to removal that the detainees might be eligible for to get them thinking about whether they qualify for relief. After that, everybody that wants to have an individual assessment or intake with one of our attorneys is able to do that if they haven't already hired private counsel. And then beyond that, we basically just serve as a resource for everybody that's going through immigration removal proceedings, going through this court process while they're detained, who might be eligible for relief, might be eligible for bond, and is trying to fight their case. So we kind of serve as a resource for a high volume of people by providing sort of more minimal services to a large volume of people, as opposed to a more traditional model where you are representing people individually and providing a lot of in-depth services. We as a staff in Florence and Eloy, we are a small staff. We have about 14 people that are sort of regularly in the facilities representing people or providing them with legal assistance as paralegals. And we're on track to serve about 8,000 people this year. So it's a huge, huge need in volume compared to our capacity. While I think this model has been, it was kind of pioneered here in Florence and has become a model for other places, I would be first to recognize that there are a lot of limitations to a pro se model that we'll probably get into more as we're talking more about access to counsel, but just a couple of them really quickly. One is we're able to prepare people to represent themselves and prepare them to assert their defenses to deportation, but then we're not able to be in court with 99% of the people that we're assisting. And so having somebody who is pro se going in front of an immigration judge And going in front of an ICE prosecutor is incredibly challenging. Obviously, the scales are not really balanced, especially when that person's in detention and trying to do all of the things that you would need to do to pursue a case in immigration court. They're really complex legal arguments that often need to be made in cases that can really mean the difference between winning and losing. Complex arguments about criminal law and immigration law that are really difficult to make. Most immigration and other attorneys don't know this area of law, so to expect a pro se person to be able to master that is really unreasonable. And then there are, obviously a lot of these cases are based on facts. So an asylum case, a case for cancellation of removal, all of these cases require a lot of factual development, letters of support, gathering evidence, having witnesses. All of those things are incredibly difficult to do pro se from detention in court. And we'll probably touch on more of the reasons why later. Another limitation is basically sort of the power of a pro se person to bargain with the government, for lack of a better word. And you see in the criminal justice system when you have defense attorneys or public defenders and a prosecutor, there's a lot of sort of negotiating that can go on in cases, plea deals or things about sentencing, things about what to plead to, and that's non-existent more or less in immigration court. I think Regina can talk about this. I think when there are private attorneys, that's possible. But there isn't, we hear about prosecutorial discretion and that there's more encouragement for ICE to exercise that, but how does a pro se person in custody who has no contact with the prosecutor until they get there in court, how are they going to try to negotiate those things? There's just not a balance there. And then similar to that is just sort of access to evidence, access to information. So ICE keeps an A file, an alien registration number file for everyone where we have all the documents. Those documents often are not provided to the pro se person fighting their case. Evidence might be submitted to somebody in court the day of their hearing. And so there's obviously an imbalance there as well. And then finally, just this sort of isolation of these detention centers, and as we've talked about all day, sort of the conditions in them and all of the reasons why someone doesn't want to be detained. You basically are setting people up for a situation where they have to choose whether to pursue their rights or take a deportation because they don't want to be detained. And on a daily basis, we see people confront that decision and make the choice that they're not going to follow through with their rights because they don't want to be locked up. And I think as an attorney especially, that's just a really, to me, a horrible position to put people in, and it's a real infringement on people's rights. So I'll stop there because we'll probably get into some of the other things later.
Thank you. Victoria?
Well, I'm a public defender in the county. I was born and raised in Colombia, so I am definitely very passionate about these type of issues. I did the whole immigration proceedings for myself on my own. And now I'm a citizen, so that's a good thing. But I'm definitely very passionate about these type of things. We deal with a lot of criminal cases on a daily basis, and a lot of them, because we're in Arizona, are immigrants and are people who are here undocumented. So not only do they have to face the criminal consequences of their cases, but most likely they're going to go deal with immigration afterwards. And as you were saying, that also impacts their decision as to how they want to deal with their criminal case. Sometimes they end up wanting to plead right away to something that may not be the best outcome for them, just because they want to go to immigration and deal with immigration and potentially be deported to be back in their country or with their families. So we have to deal with that a lot. Also now, after Padilla, the stakes are really high for criminal defense attorneys. So it's not just say, oh, well, you may have some immigration consequences. We need to learn and stay updated in the law and have to be able to negotiate pleas that are hopefully going to have not much of an impact in their immigration case. Try to figure out ways so they don't plead to something that is gonna become later an admission when they're in front of the immigration judge. But we also have the problem with resources, with a lot of the attorneys now being bilingual. And so even though there is an interpreter and even though there is interaction, I feel it's not the same. I feel it's not the same for these people to be able to speak, let's say in the case where people speak Spanish, to speak Spanish someone who can actually understand the cultural differences in the cases, and that is not just plea here and go be deported. So we work with that a lot.
Thank you. I just want to interject just briefly, just for people that don't know, the Padilla case is a case that came down from the U.S. Supreme Court in 2011, I believe, which held that there is that public defenders have a duty, essentially, to inform their clients about immigration consequences. And it's not enough to say you may have immigration consequences. You really have to be much more specific and be able to really inform your client about what they are potentially facing, especially when you're negotiating a plea, especially when you're talking about going to trial. Those kinds of things could result, although this hasn't really opened any floodgates or anything like that, but it could result in cases coming back as a result of ineffective assistance by public defenders, by criminal defense attorneys who have not informed their clients properly about what these individuals were facing once they were convicted. So anyway, that's just a little aside that informs a lot of what happens currently in the context of individuals who are representing immigrants. So, go ahead.
I'm Regina Jeffries, and I'm a solo practitioner here in Arizona. My practice area is solely in immigration law. And just to give you an idea of my office setup, I'm, as I said, a solo attorney. I have 2 paralegals, so it's me and my 2 paralegals in my office. So we have a pretty small office. But I would say that my office setup is pretty similar to the vast majority of other private immigration practitioners. I'm also the chair of the Arizona chapter of the American Immigrant of attorneys that are members of AILA. About 80% of our total membership are solos or small firm practitioners. So just to give you an idea of what we're facing, not a whole lot of people are these big, Snell and Wilmer type law firms. So with that, you really are limited as far as the time that you can spend doing certain things. And the way that I've set up my practice is that I take a small number of detained cases because when you're taking a detained case, what it means is that you're driving out to Eloy, Florence. You're driving out there not only for court appearances, but also to interview your client. You can't send your paralegals out really to do an intake. You can't send your paralegals out to do a lot of things that actually can sometimes be done in the criminal defense context here in the county. You're also having to negotiate with, we talked about private prisons and private contractors earlier. There are different visitation rules everywhere you go. So you have to constantly keep track of what's changing this week, what's the rule for visiting Eloy, and you have to take care of those things ahead of time. So there's really a lot of administrative work that goes into representing detained individuals. And not only that, but you're also dealing with the court case, but you're also dealing with with lots of other things that are going on, conditions of detention, what's happening to the person while they're detained. Family members are calling your office to find out, well, can I go visit? Can I do this? So it's a lot of management. It's a lot of case management. And on top of that, you're also talking about an extremely condensed timeline for court appearances. So if for example, if you had a client who was not detained, who was in removal proceedings in Phoenix or in Tucson, typically in Phoenix, the first appearance for someone is going to be probably about a year after you get the charging document. At that first appearance, you can ask for more time, and you'll get another year before you have to come back and actually answer the charges and the allegations. And then when you answer the charges and allegations, depending on the type of relief that you're seeking, so if you're going to present an asylum claim, for example, it could be 5 or 6 years before you get the individual hearing to actually present the case. In detention, it's much different. You're talking about maybe a month or two turnaround for a lot of these things. So everything has to be done very quickly, not only for the court's own administrative reasons, but also because you're talking about a client who's detained. Obviously, they're not going to want to sit in detention for a year while you try to get the stuff together, so to present their case. So those are kind of some of the issues that that myself and a lot of private attorneys are dealing with when they're taking these type of detained cases. There are other private attorneys, though, that actually have a different model where they take a larger number of detained cases. So they're actually spending a lot of their time at the detention center anyway. So they may see 5 or 10 clients in a day who are detained in the same detention center, and so they're better able to spend their time doing that. So their practice is more focused on the detention model, but they also tend to have more administrative things that are going on as well. So anyway, so I can get into more of that as well, but I'll just leave it at that for now.
Andy?
Thank you. Well, the first thing that we need to understand is that in immigration, there's no right to a court-appointed attorney, as there is in the criminal arena. And what that means is we're always grappling with how to provide counsel, particularly for people who are detained, but not just people who are detained, but people who are within the immigration system. And even though it has a lot of trappings of criminal law, but unfortunately it isn't by the courts looked at that way. And so as a result, the right to counsel doesn't apply. And so what we're looking for is various models in which we can provide counsel. And so you have agencies like the Florence Immigrant and Refugee Rights Project. Clearly you have private attorneys who do a lot of pro bono work. But unfortunately, we have never come up with, a model really to serve the need. Well, another model that, is looked upon is law school clinics. That is where in the community where there's a void in legal services, if there's a law school around, invariably that law school will get a call from someone, suggesting that, let's start a clinic. And, I'm a great advocate for clinics, so I'm obviously not opposed, but, isn't really a model that can deal with a tremendous problem. Obviously, it can help, but it is not, can't fill the void. Because a law school clinic has a dual mission. The first mission, and probably its primary mission, is to educate law students. And the second mission is to provide a service to the client community that it's dealing with. And, those missions hopefully are compatible, but not necessarily always compatible. And particularly because of the educational mission, then first you're looking for cases that will provide a educational experience for your students. And that may mean that you don't take every case that would possibly come into the door. Secondly, that when you're trying to educate someone, the one thing you don't want to do is, and probably no one really wants to do this, but unfortunately, and I've been in legal services before I taught, and I understand this, is giving people large caseloads. And students, you really, if you're really interested in providing a good educational experience, is something that just doesn't usually work out. So that means you're probably taking a limited number of cases. You're probably being selective in the kinds of cases that you take. That you have to deal with things like semesters ending, and so students may be starting, and in 3 or 4 months they're gone, and then and you have this case obviously that's probably going on. They have students have limited time, and so on. So it's clinics, and particularly immigration law clinics, and there's many of them now around the country, both serving sort of the general immigrant population, as well as migrants who are being detained. So we're seeing a lot of immigration law clinics. But as I said, unfortunately, they're probably not going to completely fill this great void that we have. Now, what's the great advantage of them? First of all, immigration law clinics, as I said, have an educational mission. And I think what we are doing, obviously not everyone who goes through, let's say, an immigration law clinic ends up doing immigration law, but many students do. And so I do think that we're preparing students to either be private immigration lawyers or work for a program like the Florence Project. And I think particularly projects like for are looking for students who have gone through these kinds of experiences. Secondly, even though they can't take a lot of cases, I mean, it's still, obviously, they're taking some cases. So they are, you know, they're clearly, you know, filling some need. Thirdly, law students are really, ingenious, and, you know, they're not strapped down with what happens to us all. I won't say the other panelists, but like myself, some old lawyer thinking of old ways. You know, they're kind of willing to think out of the box. An example, in our immigration law clinic at the University of Arizona, we had a case of where we were seeking deferred action. Well, the student, and that's where you ask the immigration to kind of put the case on the back burner. It's kind of what's happening today with the dream kids. And the student came up with the idea, this wasn't a dream case, this was long before that, with doing a videotape of the life of this person. I mean, to really, because when we presented to the district director, instead of just presenting a cold record of, the kinds of things that this person does, we ended up, the student ended up making this really interesting and compelling videotape. Well, obviously there's a student who kind of thought out of the box and was successful. As far as clinics and the kinds of models that we see, I mean, there's clearly direct representation, and which many clinics do. You also can have clinical students placed with agencies like the Florence Project, and so that's obviously, if getting it back from public prisons to private prisons and the whole economics. Well, obviously a placement clinic's cheaper than a one that you run outside the within the law school. And then there's the self-help. That is, again, the kinds of things that the Florence Project does, an immigration clinic can do as well. That is, assist people in representing themselves. And the immigration law clinic at the U of A kind of does both direct representation and self-help work. So clinics can help. They clearly need to be part of this attorney, this need for attorneys in this field, but it's not a panacea where we can really resolve this really great problem that we have in this country, where we incarcerate people and we don't provide counsel for them in any of these proceedings. And so we're all grappling, how to meet the demand. And obviously, we're not doing it now, and clinics can help with that, but it's clearly not the solution, the complete solution.
Thank you, Andy, and thank you for the background information. We had neglected to sort of give some basic general information about the fact that people who are in immigration detention or people who are in immigration proceedings are not entitled to counsel, unlike individuals who are accused of criminal offenses. So that's something very, very important that underlies everything that we're talking about here, really. Okay, so I'm going to ask Regina a question. Regina, I've been detained. I'm undocumented. I don't have a family here. I don't have any money. I've been picked up as I was crossing. How do I get a lawyer?
Call Lindsay.
Oh, my cell phone. So, am I completely, is a private bar inaccessible to me?
So that's a great question. I mean, my understanding is that when somebody's detained by ICE, first of all, let's say they're in Phoenix and they get picked up, they first get transferred to an ICE sort of holding facility where they're like shipped out to wherever they're going to be. They do like an initial intake and then ship people out to the detention center that they're going to stay at. And when they're sent there and issued a notice to appear, they're also given a list of pro bono counsel is what they're given. This is actually a list that I think is actually developed by the Board of Immigration Appeals, or EOIR, the Executive Office of Immigration Review. But what it is basically a list of attorneys, mostly private attorneys, but also some community organizations like UFW Foundation, who have accredited representatives who provide like low-cost legal services, or Friendly House or something like that. And so these individuals are able to make a phone call to one of these organizations or to a private attorney on the list to try and get someone to help them. The problem with the current model, though, is that for private attorneys, basically, if you have someone that has no family, the person doesn't have any resources, it's going to be very difficult to get a private attorney just to pick up the phone and say, yeah, I'll do a pro bono case for you in this instance. I have to say, immigration lawyers in general, and particularly the private immigration bar and solos, do a ton of pro bono work. It may start out thinking that you've got a paid client, but it ends up being pro bono or low bono. So it happens all the time. It's not like there's this really formal method for private attorneys to get pro bono cases, but believe me, it happens a lot. So the person would be able to call, but if that private attorney is not able to take on a pro bono case at that time, what they, probably would end up happening is the person would get shipped off to the detention center and then go through one of the Florence Project, rights presentations, and maybe they get picked up by the Florence Project to get them matched up with a pro bono attorney elsewhere. But typically, if that's the situation, that person's probably not going to be represented. And I think that the numbers of people that aren't represented are really high. I think it's like over 50% of non-detained cases, and I don't know, the numbers are extremely high though.
So you're saying that 50% of non-detained cases are unrepresented, and detained cases probably even higher, right? Now, in terms of the non-detained cases, how do lawyers reach out? How do people get informed so that you can reach that 50% that is unrepresented?
A lot of what happens is I represent like entire families, basically. So people that most people get your information by word of mouth. So they know a neighbor who, had used your services in the past or something like that. So a lot of it gets passed along through referrals. Also, the information sheets that are left at the court. But also, the American Immigration Lawyers Association has a database of members, and actually most immigration attorneys, typically if they're practicing on a regular basis, almost all of the immigration attorneys that are practicing are probably members of AILA. And so, there are different ways. I know some attorneys also advertise, things like that. So yeah, many different ways they might get a hold of you.
Thank you. Lindsay, I have a question for you. You talked about the Know Your Rights presentations and working with individuals within the detention centers to figure out how they can represent themselves. How successful are the individuals who end up representing themselves in the proceedings? And it's kind of a two-part question. If that model has limitations as you have described, what in your mind would be sort of the ideal model for representing immigrants in Arizona? Let's just say here in Arizona, our context here.
Okay, well, the first is how successful people are. It's sort of hard to quantify a little bit because the services we provide are kind of in stages. So a lot of people will just go to one of our rights presentations, have an intake, and then we might not think they have a strong case, but they might want to go ahead and pursue it. So one example of that are people pursuing gang-based asylum claims here in Arizona. In the detained context, those cases are nearly impossible to win. So oftentimes people are going ahead pro se, but they're not necessarily receiving a lot of assistance from us, and they're not usually successful in those cases. But cases where we are providing pro se support and where we might write a motion for them on a legal issue or support them for their final merits hearing, I think our success rate is probably about 20 to 30%. So not very high, but pretty high.
Is some of that represent or counseling or assisting people in representing themselves in bond hearings only? Or are you talking about merits?
More merits hearings. Most of what we do for bonds, or we do workshops with people and basically tell them what documents they need to collect, what they need to do in order to kind of have the evidence together for bond. But for a merits hearing, which is the sort of final trial, for lack of a better word, where people are actually putting forth evidence for their case, we're helping people prepare their own testimony, write a declaration if that's relevant, and collect supporting documents and evidence that they might need to do that. So, and then the second question, what would be sort of the ideal? I mean, obviously, I think the short answer that people say is that the same, right to counsel should attach for people in civil proceedings, and so we should have something like a public defender system for people that are going through, removal proceedings. I think my first response to that would be with respect to detention. I think the numbers should be way down, and frankly, I don't think anybody should be detained. So I think if you scale those numbers down to a much lower level, I don't think it becomes quite as much of an issue. I think there are challenges for people that are not detained to find counsel, and I think not having that right when you're released in the community is not good either. But I think your ability to locate counsel, your ability to pay for counsel, obviously is a lot different if you're not detained. But if people are going to remain detained, I think there should be I think that counsel should be appointed. I actually think that sort of a hybrid approach that involves a little bit of what the Florence Project does and an appointed attorney would make sense, because I think that because these facilities are very remote, having kind of an organization that sort of acts like a resource for everybody on things like bond, things like orienting them to the system, maybe could get involved in more advocacy on conditions issues or accessing files and evidence is helpful, and then maybe once somebody's fighting a case, they can actually be assigned an attorney to handle their case with them in court. So I think there are benefits to what we do in that it's a kind of a more creative approach to lawyering, and we do find that we really empower people to kind of take ownership over their case, which I don't know, how that is in the public defender system. It'd be interesting to get your thoughts, both of your thoughts on that. I don't know that you want to jump right to that model where it's just sort of like, oh, here's your attorney, hand it over, I'm not really involved in my case. But I think absolutely, if somebody is fighting a case and they're detained, that they should have an attorney handling their case with them.
Andy, you want to jump in?
Yeah. Well, first of all, as the government becomes more aggressive in this field, I think the government has some responsibility. Clearly, people who are legal permanent residents, who are being, there's removal proceedings against them. That is, they're trying to deport them. Clearly, that group of people who have roots in this country, who have equities in this country, should have a right to appoint a counsel, whether they're detained or not. Clearly the ones who are detained, and plenty of them are detained, but even the ones who are not. So we should at least start there. And hopefully someday a court, the courts will find that at least that group of people have a right to a court-appointed attorney. Now, obviously, we can go from there. But if we don't even provide it to that group of people, it's hard to argue that people who are either undocumented or here temporarily should have a right to counsel. So at least if we can, start there, first of all, I think we would do a whole lot with the system, and secondly, at least maybe then we would, see some movement. But so there is a place, and I guess if you don't know, we do deport legal permanent residents.
And
So-
U.S. citizens sometimes too.
What?
And U.S. citizens sometimes too.
Well, there are.
There have been
So-
those cases. Andy, you're a law professor. Is there somewhere in the Constitution where we could find this right to counsel for individuals who are facing removal proceedings?
Well, the problem is that, right to appointed counsel comes in, the criminal context at this point. And immigration proceedings is kind of this hybrid proceeding that's, at the most is, sort of a civil criminal kind of that are used to remove people from the U.S. And so that's always been the problem when, this argument has tried to been put forward about the right to appointed counsel in immigration proceedings. But really, it's
Common sense?
It's really a
Fair.
ridiculous argument, because if you
Right.
talk to a non-citizen, as a matter of fact, if you talk to a non-citizen who has committed a criminal act, and they really do understand the consequences, both the criminal consequences and the immigration consequences, unless they're facing a great deal of time that is a very serious criminal proceedings, if they're the sort of normal criminal proceedings, they're much more concerned about the immigration consequences than they are the criminal. As a matter of fact, I'm sure most people would, I'm not saying they would like it, but if they knew that by spending a few years in prison on the criminal side, they would not be deported on the immigration side, they'd take it. Because it's really the immigration side that concerns them more, the separation from their family, all of the things that we know about when someone is deported. So this idea of putting this thing forward to deny counsel by saying it's not a criminal proceeding, but when you talk to the people, many times it affects them more than really the criminal proceedings affect them, and so on. So hopefully, the courts will come around at some point and at least say that legal permanent residents, I'm not saying the others shouldn't as well, but at least legal permanent residents.
Thank you, I agree with you entirely. That's certainly been my experience with representing individuals who are potentially going to be deported. Victoria, you are not escaping. I have a question for you. Until a few years ago, it was possible for immigrants to get bond in state court. Can you talk a little bit about the state of that, how that works, if at all, in Maricopa County? And also, how, as you discussed Padilla, how as a public defender can you provide the best support you can for your clients who are going to be subject to removal?
Well, the answer to that, unfortunately, is there's a lot we can do, but there's also nothing we can do. And it's, in the background of whether or not a person can have a bond, it changed a lot in the last, this was probably 2005, but basically when a person gets charged with a criminal charge, anything, automatically, based on what they say or based on what the arresting officer thinks or whatever other evidence they think they have, they get to the conclusion that the person is in the country undocumented. So they place on them what they call an INS hold, which is basically saying we told immigration authorities that you committed a crime and that you're being held in the county with these charges, so you're not eligible for a bond, period. So that person obviously has to sit there, and that's when I said that it comes to, here's a plea offer that may not be the best, or you can go to trial and fight your case, and no one wants to do that because they're gonna have to sit there for who knows how many months waiting for that trial to happen. So all those people are not eligible for bond, and they just sit there. So, and that's when
Really until like only a few years ago,
until after
they
you, right.
could get bond,
There
right?
was a Simpson case, and in some cases you can ask for a Simpson hearing, which is basically saying we have evidence and we can prove that the person is not here undocumented, so please give this person a bond. And they're not very successful, and we don't really get many of those cases. Now, the reason why I say there's not much we can do is because at that particular point, we can't really get into their immigration case. We're gonna have to solve their criminal case, then they're gonna go deal with immigration, and it's a whole different animal for them, and that's when they're gonna deal with federal law and all those things. In the meantime, we're just gonna babysit them in a way. So there is a lot we can do in the sense that we can definitely try to get pleas where the person is going to have the minimum amount of immigration consequences possible. What the state wants to do, for the most part, and I'm not going to name anyone, is try to get these people with some ridiculous charge. So they plead to something, they go to a detention center, they get deported. We all know they're going to probably come back, and when they come back, guess what?
represent them.
Not only are here undocumented, but they have a prior felony conviction and they have a criminal history. So we're going to give you a lot of time in prison for that. And what happens is, for example, if you are stopping a vehicle and you show a driver's license from Mexico and you're here undocumented, that's a class 4 forgery charge. A class 4, which is presumptive 2.5 years in prison, even if you don't have any criminal history, and you are a felon at that point, once you're convicted.
Is it also forgery to use a false name? If you sign a print card?
Anything. Giving a social security number, even if it's a made-up social security number to work, having a fake ID, telling the arresting officer that you are here legally when you're not, you name it. So there are things we can do, and I think that our office particularly has been concerned with this because we see so many of these cases and they're very open to do this. So for example, we just started this training for new attorneys where we teach them how to represent Spanish-speaking clients for the most part, because that's what we get. And in that's when I come in and tell them that there's more to the representation than just what you have to do in any criminal case, because there are a lot of cultural differences, and those cultural differences are going to be reflected in how they see their cases, and how, for example, the role of family in their cases. They're not making the decision just for themselves. You have to talk to everybody, and everybody's going to come to court, and they want to be involved in this. You have to be very aware of what the type of cases, the type of charges, for example, in sex cases, is a whole different culture on how, the Latin culture, for example, see these kinds of cases versus the way they're seen in the United States. So in that sense, I think there is a lot that can be done. There is as basic as getting their name right. So it's a lot of teaching attorneys as well to have this kind of sensitivity to be like, you know what, they may have 2 last names and it may be a little bit longer for you, but it is an issue of respect. You call them by their name. So I definitely think that that's the only way that we can help it, because we also are in this position where we have to tell them we're not immigration attorneys. You're going to face consequences, and I'm going to try to do my best, and this is why this charge is better than this charge. But at the end of the day, once you get out of county, you're going to have to deal with it by yourself or hire an immigration attorney.
What, who else said?
You're right, go ahead.
I see it every day. No, it is not difficult at all, because then we go into SB 1070 and you name it. But as I said, a lot of this is police officer stops you for a traffic violation and says, you don't look like you're from here. Do you have an ID? And then they show their Mexican voter's ID or something like that, class 4 forgery. And then you are in county jail until your case is solved.
Or a police officer stops you because you don't look like you're from here, and then they smell alcohol in your breath. You know.
Well,
So, because the DUIs to me are very interesting. A lot of, in federal court, we see a large number, and this has changed over the years. I've been at the Federal Public Defender's Office for 10 years. I used to see mostly prosecutions for illegal reentry where individuals would have aggravated felonies. Now we have a lot of prosecutions for individuals who have just straight out felonies, not aggravated. A lot of them are DUI convictions. And you'd think that the entire Latino population of Phoenix is out driving drunk if you look at the numbers and how they kind of look on paper, that everybody's out driving drunk. Well, it just, so happens that that's who gets pulled over.
I think something else to add to this, just from the immigration perspective, is that it seems that the county attorneys also tend to figure out which crimes will actually have the most immigration consequences, and then they'll often offer those kinds of pleas, and as Victoria said, people aren't wanting to sit in jail. I mean, this is something that's actually happened in the last year with the forgery. They used to offer like class 6 criminal impersonation, which could be ultimately reduced to a misdemeanor, which would avoid immigration consequences, but that doesn't happen anymore.
Well, and the county attorney actually has a policy because they believe that if the person already committed a crime and the fact that they're illegally in the country, why should we give them the option to have a plea that is going to help their immigration? So they actually have a policy in place where those pleas are not available anymore. And you can give them all kinds of reasons why it's going to be beneficial and why it doesn't really change for them. Whether if the person pleads, for example, in a case of a fake ID to a solicitation to take in an identity, that person is going to have an easier time in immigration than if they plead to possession of a forged device, for example. For the county attorney, for purposes of the time that they're going to spend in jail, it changes absolutely nothing, but they don't want it because it's going to make them a little bit.
So would you say that is it blatant? Is it in writing? Because I mean, to put that in writing would evoke an equal protection dilemma.
A lot of their policies are not in writing, but they will say, well, it's a policy, we can deviate. It changes constantly. And that's actually another thing that attorneys can do. I think if you have a little bit of the sensitivity for it, and I have done it myself, you can make a lot of arguments of proportionality as to what people who are here undocumented, the type of pleas that they get versus people who are not. And I personally think that it's very obvious that there is some kind of differences, but I'm not getting anywhere with that.
Go ahead.
This is a comment, sort of a talk back to both the panel and a thank you to Human Rights First for convening these kinds of discussions. I think it's extremely valuable. And this panel in particular makes me reminded of the importance of looking at the bigger picture in which we're having these discussions, because it's not just about tinkering with how to make it nicer, offer more services for immigrants. We're really trying to find out the basis of how we can take some of the best lessons of criminal justice reform and apply them here. And I think, Andy, your point about hoping it applies eventually, at least the right to counsel applies eventually to immigrants, at least to certain categories, I think is so crucial, because my understanding is that deprivation of liberty is the basis under which you derive the principle for the need for counsel for the groups of people. So de facto, we need to have that revisited and brought out to the public attention. That's one thing. Another thing, too, is well, I'm miserable, you know, lots of things about human rights concerns from having worked inside, and I'll skip those kind of comments for now, but I think for best models, once you try to settle some of these really big constitutional things about what are we doing, and on the basis of how can we do this, if our own rationales for other things can't even be applied within our system, we need to have out there the critiques about the political nature of what's considered a crime, and the political nature of sanctions, and the political nature of the organizations that apply them, and how we can justify differential treatment on the basis of equity criteria for different groups of people. I think that needs to be also brought out as a major glaring concern for us here, instead of just talking about what services. Just for right now, what can we do? I like Lindsay's idea of a hybrid model, of a mixing of the FERP model of LOPs plus an appointed counsel.
Should the officer on the street even be having that discussion about where are you from and you're supposed to be here? And what was very eye-opening to me, which I never even understood myself until this whole immigration, the Proposition 100 and all of that came in this state, was initially we would see people in the jail, and I had a very dear friend who was a federal public defender who gave me a poster to hang in my office that was the road to immigration, that looks like one of those mouse mazes that, you know, the different arrows, the path to immigration that has 17 different arrows pointing in 20 different ways. That, you know, I would speak to groups and say, okay, who in this room is a citizen? And everybody in this room could raise their hand and know whether you're a U.S. citizen or not. I never realized or knew that we could have people who would answer that question, no, I'm not a citizen, who actually had, at some point in time, gained legal permanent status. So you're even asking people questions who can't answer it properly at times. They don't know what the answer is, either based on somewhere along the line they're piped through the system and they don't know it, how long they've been in the country, or so. And that's a concept I didn't even realize, and I don't think many people do. And so people are detained based on what they answer an authority figure. That is what their belief is at that point in time. And so I think there are even nuances that people are not aware of. And so that intervention of informed counsel at the very earliest nexus before you're even going there is critical.
Sure. I completely agree with you. This is actually one of the barriers to counsel, though, that's really significant, is that when somebody's being passed from the county, let's say, to ICE, to that initial processing facility where their case file is being reviewed and ICE is making the decision whether to detain them or not, whether to issue a notice to appear or a charging document or not, it's extraordinarily difficult to get ICE officers to recognize that you actually are someone's counsel. The respect for someone being represented in the immigration realm is nothing compared to what it is in the criminal realm. There are pretty severe penalties. There are pretty clear procedural rules and things like that in the criminal sphere where, you know, obviously a prosecutor is not going to be able to talk to somebody's client directly without them knowing. Well, that doesn't happen in immigration, because even if you've entered your appearance, they don't care. They go and talk, or they'll say, wow, you know, you've got a really bad attorney, you should just sign or whatever. And I mean, it happens constantly. It happens with non-detained people, where you're going to the immigration office, your client is there and you're 15 minutes early to the appointment, but the immigration office has taken your client in for an interview before you've even gotten there and haven't had them sign a waiver of counsel form. I mean, the process is extremely skewed, and, you know, unfortunately, the agencies just don't recognize the right to counsel like they do in other aspects. And I mean, you're absolutely right about people deriving citizenship. I mean, probably a lot of people know this, but you can become a U.S. citizen by being born here, or you can derive citizenship even if you're born somewhere else, if one of your parents was a citizen. But there are about 1 million layers of that. I mean, the laws change every 10 years, and depending on when you were born, you have to look at when you were born to decide which laws were in effect for you. And so I've represented a whole boatload of people that didn't even know they were citizens until I took a look and I was like, well, actually you're a citizen.
Or they are allowed residency, or they have legal permanent permission to be here, or whatever.
That's not quite as common, but I have definitely seen those people as well, where I had a daughter of a client that had been granted permanent residency. She didn't know. I did a FOIA, and I'm like, yeah, you're a permanent resident for 10 years. She thought she'd been living here without status. So it's great. And Lindsay, you probably see the same thing. So it's a mess.
I have a couple of questions. First, thinking about pro bono culture, pro bono counsel as a potential resource. You know, Human Rights First, as you know, represents indigent asylum seekers using a pro bono model, but we don't really work with immigration attorneys or immigration law firms. We work with firms that don't have an immigration practice and then really handhold the attorneys who are doing the pro bono work. And so I'm wondering if there's, you know, but we also are in a huge city where like all the major firms are headquartered. So I wonder if there's any potential or use of that avenue here.
Yeah, I mean, usually we refer the more challenging cases where there are criminal immigration issues to the private bar. And as Regina said, the private bar here is like they do a ton of pro bono, and they're incredibly generous with their time for our referrals, but then we do refer to law firms as well. And what we try to do is kind of like build up expertise within the firms. I mean, the limitations on it are that obviously the remoteness of the facilities, people's willingness to come down, language, which I think Victoria pointed out, a really important issue about just being able to work with your client not through an interpreter or get the cultural differences. And I think that's important. I mean, that's not to say that there aren't great pro bono attorneys at law firms, but it's not ideal. And then I think also it's really hard to find cases that are like straightforward and don't have unexpected twists and turns that the corporate attorney who's doing this to learn might not really want to be in it for the long haul for a case that could get really complicated or go on for several years or prep all family lists. So I think we have those relationships, and there are a lot of really wonderful pro bonos, but I don't think it's a solution. And I mean, I think it's, as Andy mentioned about clinics, I think it's one of the things to throw in the mix, but I don't think it's ever going to get us to a point where, I think it's just going to be a limitation on how many.
Yeah. Are you offering law firms in New York to help us out here? Is that what you're trying to say?
In my back pocket, yeah. My other question just quickly is, or not quickly, but you know, the lack of government appointed counsel and thinking about a model in which that could be delivered, perhaps more limited only for long-time permanent residents. But I'm wondering thoughts on how to avoid a sort of Operation Streamline mass representation disaster in a situation like that, where you do have government appointed counsel, but the representation that's able to be offered is completely pathetic.
Right. I mean, clearly Operation Streamline is not an example of what we should be striving for. And of course, that's the criminal side of immigration law. And of course, we're talking about the civil side. I mean, I would perceive, just like you have public defender's offices, you know, you could have the same thing for immigration. And personally, I'm in favor of anyone who goes through the immigration system to have a right to court-appointed attorneys. I'm just saying that LPRs that clearly have the best case to, to put forward, because, to get around, the whole issue of, deprivation of liberty for counsel. You know, we also in this country, courts have said deportation is not punishment. Well, talk to anyone who's being deported, and you know, I'm sure they're not looking at it that way. And so those are all the barriers. But I would, you know, so Streamline is not an example, or you know, in some ways may not even apply to at least I think what we're talking about. And you know, and so I could, you know, see like a public defender's offices, and there's some foundations that are now kind of looking into that. Isn't that right, Lindsay? Isn't there? I mean, looking into that model of using a kind of like public defender's offices, that kind of model.
Yeah, I mean, I do think that concern is real, though, which is why I was thinking like a hybrid approach, because I think once you create, you know, a council, I think it can, you know, we have run into that issue, not as much now, but years ago with people with mental health issues, where the judge, you know, there was a competency issue that became clear, and the judge wanted us, as the Florence Project, to enter an appearance, essentially, and the ultimate decision might be just for that person to be deported, but you wanted counsel on the record, right? And you couldn't really work with that client to figure out what they might be eligible for. So, I mean, I think there is, it's important to be aware that that system could be set up where it's just sort of like a streamline to deportation, and having attorneys kind of be part of that to move it along is dangerous. So, yeah.
I mean, it has to be meaningful representation. It can't be like, I'm not being critical of every Streamline lawyer, but obviously a lot of them, it's just you know, going through the motions.
One last question up there.
Maybe the last one yourself, but yeah, it was interesting that we brought up justice as being in this one frame, and I'm thinking government is also a form of security, and there's a certain idea of federalism versus state rights, which is there in the Constitution, and we have 4 land border states. So if we made any comparison between Arizona, California, and New Mexico, Texas. And the other thing that comes to mind is we not only have 4 border states on land, we have seaports. We have Cubans being turned back and sent back to Cuba, Haitians, whatever. We have a number of situations where we apply immigration law, and are we doing it the same? Doing it different? Why are we doing it? What is the basis of the law? Is there a point to having states with any rights? The federal government fails to provide their guidance, the ratabates, whatever, and does not provide its own facilities and its own resources. Personally, as a state taxpayer, I'm insulted with public education in Minnesota. The councilwoman doesn't even know where I'm at. That doesn't make sense. Happening here, and what we're focusing on, and what should be happening in larger scheme of things, how it should be prepared and supported in our efforts to make things more direct. Frankly, Carolyn Isaacs made a very good point. This all would be shrunk to manageable size if we actually had a working program, in my honest opinion. So I don't know if there's any comparisons quickly made towards other states and other means of immigration without documents or illegally, however you want to nicely term it, but showing up in our borders without any rationale for being. Is there a comparison to be made? Are there things ready to benchmark ourselves? How we do it differently in Arizona?
I mean, I think that there are, you know, the 4 border states, obviously, there are different sectors of the federal government that are dealing with the different, because when somebody's crossing over, if somebody's apprehended crossing in, they're going to basically be transferred over to the federal government. So the state's not really going to have much of a role in that, which is my understanding.
Well,
but
we spoke about stopping people and asking them, are you here legally? So that's a local agency enforcing federal law. Is that correct?
Well, with that, yeah, I mean, with the SB 1070 thing, I mean, it does happen in other states, but not to the extent that it happens here. I think what we've seen in Arizona over the last, you know, actually the last probably 10 years is just an increase in the number of people that are being pulled over who basically on the basis of what they look like and what, I mean, I had a client that was pulled over for turning into the wrong lane. It was a family of like 6 Latinos on their way to Walmart on the west side. I've turned into the wrong lane 8 million times and driven with a cracked windshield. I've never been pulled over. So, I mean, I think that there definitely is a higher instance of that happening here. But, I mean, one thing that you can look at too is the way that the federal government deals with things, like throughout the border states. This is actually something that the district office told me, the district USCIS office here, is that Arizona has one of the highest numbers of border crossers in the United States. Yet the credible fear interviews for asylum, like the asylum cases that actually come out of those crossings, are far lower in Arizona than they are in places like Texas. And that's a function of what border protection is doing along the border. Because I can't tell you how many cases I've seen where somebody has expressed a fear but's returned anyway without actually being given the credible fear interview or given the opportunity to present their case. So there is a difference in that respect along the borders.
Here in the immigrant.
A fear of persecution, of returning. So an asylum claim, like they fear being persecuted in their home country. And under international law and under federal law, we're not allowed to return those people. Yeah.
Okay, well, I think we brought about 10 minutes over, but I thought it was an interesting discussion. Thank you very much to all the panelists. Thank you to Evelyn for organizing this, to Ruthie and Human Rights First. And I think that wraps it up for us. Thank you very much.
That was one of the reasons why you had a riot in Attica. Prisoners didn't know what their future was. Disparate sentencing between upstate and downstate. You know, having more fixed sentences isn't necessarily bad. But the facts I give you are what they went to prison for. I don't deny that some of them have been good and they're down to minimum security. I don't deny that at all. I'm glad to see that's happening.
That's not the way it works.
Okay, can we get some other questions there? Thank you for your question. Yes, you.
I think that the most important problem which Caroline has mentioned is that if we have private prisons, then we have companies which are earning money on having people detained. And obviously afterwards there's lobbying to having longer detention periods, to having more severe punishment. So I wonder how the supporters of private prisons can address this problem.
Well, I would just say that you can apply that same argument to doctors. You know, I mean, doctors make more money if people stay sick, but they don't do it that way. You know, they don't have, and I don't know how a private prison operator can determine if someone's going to stay longer. I mean, that's usually something set with the judge, and there's very little leeway with truth in sentencing, so.
No, but there is a lobby.
Okay, why don't we get the commissioner's response as well to your question, if you don't mind.
I'm sorry, so say it again very quickly.
Well, basically, if you have private companies running the prisons, then in their benefits, in their interest is to have more people detained and people being detained for longer. And there's
the incentives.
There's strong lobbying for having the punishments and longer. So how do you
it's not been, it's not, I don't have firsthand knowledge, it's not been my experience. They are actively involved in lobbying, but the lobbying is that where there are beds, that those beds be made available to them as private beds. I have not come across, I'm not saying it one way or the other, that they lobby for sentencing change. And that's the only way that you would really create that kind of capacity.
But what I heard is that the fact that, for example, like the fact that migrants are very often detained in the U.S., it's one of the reasons is that there's a strong lobbying on the side of prison companies who it's in their interest to having migrants very easily detained because they are earning money.
So that was something I addressed earlier. Congress in 1996 passed a series of immigration reforms, and they substantially increased the number and the nature of people who either entered unlawfully or remained unlawfully for mandatory detention. But that is an act of Congress that was passed in 1996 that today still plays itself out as large numbers of people who are subject to mandatory detention for violations of civil immigration law.
Did you have any additions, Carolyn, before we move to the next question?
Oh, many. And I know that we're short on time. I mean, I think that there's, certainly CCA, for example, will say, we have a policy that we will not lobby for increased sentencing, right? But that's not what our lobbying for. Our lobbying is for, I don't know what they say it is actually for, but you can very clearly see the pattern, right, and the outcomes of those patterns. If you look at Arizona's SB 1070, for example, right, the governor's two top advisors were current or former lobbyists for CCA. You have CCA Geo Group spending a lot of time and money and energy in Arizona talking to our legislature and to the governor's office. There are very clear relationships, and there's a pattern in terms of how these corporations operate. It's a very smart business model. They wouldn't do it if it wasn't successful in getting them more contracts.
So let me just step back for a second. So we've got disputes about the facts, right? Disputes about the costs, and those are central to this debate. We have disputes about motives, and that's what's coming up in this context. But one area where I was struck that we had at least the potential for some, more constructive dialogue was on this issue of transparency. I think the representative asked, what is your model transparency legislation, and express some openness to it. I tried to get earlier, Carolyn, your specific suggestions on that matter, and I know, Commissioner, that's an area that you've had some experience with as well. But before we get to the next question, I'm wondering if among you three panelists, we have any common ground on that dimension, recognizing that other areas are quite contested.
Yeah. Well, at first glance, to come out against transparency, it would be ridiculous and suicidal. I guess the question I would ask is, what's the current policy? Is Arizona's policy greatly different than what other states do? If so, why? And if this is proposed, how would the private prisons reply? What would their problem be with it? It's a complex issue, but I don't think that people should be denied information without good cause.
And I'll just get super concrete. House Bill 2203 basically boils down to that any private prison operating in the state of Arizona, so that would be those under contract and those not under contract, must make available on request all records pertaining to the contractor's costs, operations, staff, and inmates to the same extent required of public prisons and jails.
I would also contend that the reports that we use that determine what directions we're going and what the trends are need transparency also. As we all know who work in any sector, where a report is written and how statistics come out can be very different. And I think that there's a level of transparency there, that where those, who writes that and where those come from can be very different. And the independent observers need independent observers almost.
So if you could just explain for those who have not read this bill, what is different in it than it is now?
That currently those corporations do not have to provide any of that information upon request to public. There may be, and for those that are simply operating in the state and are not under contract with the state of Arizona, they don't have to provide it, even if our state government requested it.
How does that compare to New York?
New York is very aggressive when it comes to informational requests, the time that we have to produce requests and the things that must be produced. There is very little that can be redacted in New York. It seems like there's different kinds of transparency. There's the core components of the contract. So what is the fundamental agreement, and it's the four corners, all of its parameters, but then the extent to which it adheres to its contractual obligations, which is the evaluation, which is both outputs to some extent, but more importantly, the outcomes. So there are certain benchmarks that would be held constant, whoever it is that's delivering it. But as I had mentioned before, the situation that Arizona is in now, because you have some facilities that are built and operated without input from government at the local or state level and can't respond if it's faced with an emergency, that kind of transparency is critical as well, that every business has some kind of licensing and some licensing, not for over-regulation, but just to ensure minimum safety and security of the host community should be part of that.
Did you want to comment on that, Referrals, before I take another question?
It's very complicated. I mean, there are certain company confidentiality, things that aren't necessary to know, that you want to protect them to keep them competitive. There's prisoner privacy issues. It's a real complicated area, but I don't believe that if it's being paid by the government, that they should not be held to reasonable transparency standards.
Okay, do we have other questions? Yes, sir.
I guess for Caroline, what are some of obviously you're not, you don't like the privatization idea. So how are detainees' human rights more ensured if they were in a state-run facility rather than privatized? And then I assume that your argument would be that there are. Do you think that those are human rights that the taxpayers would be willing to pay for? Because it sounds like it would come down to a cost issue.
Great questions. So again, I'm not going to say woohoo ICE detention or woohoo Arizona Department of Corrections. I think that's another point of agreement, is that many of these systems have some serious problems that need to be addressed. My concern is that then when you add another